self-assessment tax. GST is a self-assessment tax where the proper officer is of the opinion. If a proper officer is of the opinion that the person has failed to correctly assess, deposit the tax to be paid, or where input tax credit has been wrongly availed or utilized, or tax has been erroneously refunded, etc., then the GST department will come and determine the tax. Until that point of time, it is a self-assessment tax assessed by the role played by qualified chartered accountants mostly, and of course consultants, GST consultants are also helping them to determine the tax, what need to be. It is a self-assessment. It need not be accurate. That's the fundamental point I'm trying to drive here. It is a self-assessment, not that every assessee. It doesn't say make use of chartered accountant. It doesn't say, law doesn't say make use of chartered accountant, see whether you get a certificate true and correct, and then file GSTR1, GSTR2, GSTR3B. Fundamentally, the law doesn't mandate accuracy of filing of the returns. You have assumed as a professional, if any mistake you do, it is fatal. Actually not. Actually not. That's what the confidence I wanted to give you. Law doesn't mandate. Law says GST is a self-assessment tax regime. You as a self, when I say self, I am an assessee. Let's assume I am a registered dealer. Then I register and then I pay taxes. I need not know every law. As per my assessment, I will pay GST. I will file GSTR1, GSTR2, GSTR3B. If there is an auto population that comes under GSTR2A, then I'll check what is the reason of difference. This is the system in place. But how is it seen now by the department? As though every businessman, every MSME, micro, small and medium enterprises, everybody who runs a food outlet and makes a turnover more than 1 crore seems to have a knowledge of GST. It is deemed that they should have a knowledge of GST. And or he has to approach someone, consultant. How can consultant also have every knowledge of GST? When the department itself doesn't know, or the government itself is not clear of the position of law. So this is the fundamental thing. Take out from your mind that the GST when you file has to be correct, because there is not about true and correct. Because if the intention of the law was, true and correct, then they would have told GST is a self-assessment tax regime where you have to file your return in a true and correct basis. But it doesn't say self-assessment. Assessment itself means you assess as per your knowledge and you file. So you are protected to that extent. You don't feel guilty when you make a mistake in filing. That's what I'm trying to help you out to come out from. Second, what if the department wants to, if the proper officer, very important, who is a proper officer again is a question. We have many jurisdictional issues now pending before high courts. For example, the inspection is conducted by another commissionerate, and then based on that inspection, summons are issued, or the notices are, show cause notices are issued. Based on the show cause notice, the appeal process carried out. Now, what are the issues with respect to jurisdiction, with respect to proper officer comes into picture. So whenever you issue a notice, very important, check whether he is a proper officer who is authorized to give the notice. I'll tell you who is a proper officer shortly. This is the context I'm trying to set. Second, error cannot be a fraud. Mistake cannot be a fraud. We are all chartered accountants. We are a chartered accountant fraternity. We know a difference between a error and a fraud. And when we do the audit, we only give true and fair opinion. Why fairness? Sometimes auditor may not be able to detect fraud. What has happened now? How is the jurisprudence evolving now? Any fraud that happens, chartered accountant is responsible. How can a chartered accountant be responsible? Our clearly, as per Kingston Cotton Mill's case, it is true and fair view that we have to express opinion. That is, we are only watchdog and not a bloodhound. Even today, that is the position of law. But with respect to GST, we are all expected to file an accurate thing, which is not our role. That is the reason government itself has corrected the audit report from true and correct. True and correct. So I knew this because Why did the government correct true and correct opinion, a correct certificate? In fact, true and correct is always a certificate. It cannot be opinion. Only fair, it is opinion. No, true and correct certificate. Initially, it was there in 2019, 18 and all, when the certificate was supposed to be true and correct. The government corrected it. I was part of the discussion with the Commissioner of GST in Tamil Nadu when this discussion happened with respect to true and correct. So I said true and correct. In my representation, I said true and correct is literally means certificate. Nobody can certify in a position of law. How can I expect chartered accountant to be certified in a position of law? Because based on the position of law only, I would have taken input tax credit. Based on the position of law only, I would have classified based on HSN code. Based on the position of law only, I would have paid 12%, 18%, 5%, 28%, whatever the rates the government fixes. There's always a possibility there will be a bona fide reason that what I have assessed, what I have understood may be very different. And accordingly, you can't bring true and correctness with respect to the GST. So today, I'm going to deal with how does a proper officer proceed to determine the tax? The proper officer, I'm not going to place any PPT. I just wanted to articulate the subject so that you receive the subject as an articulation. So that further we will, I'll come to the branch and discuss about in-depth about the issues relevant to Pondicherry and practitioners. I know what are the businesses in Pondicherry, tourism, and I know what are the businesses, liquor shop and hotels. We will do in-depth sector-wise analysis I will do when I come to Pondicherry, I assure you that. But today, I'll just introduce where he may proceed to determine the tax, interest and penalty payable by such a person, that is assessee. In order to do so, the proper officer is required to issue a show cause notice. Proper officer is required to issue a show cause notice. It's a big phrase. This itself has not been fulfilled by the department properly. There is a confusion with respect to proper officer. There is a confusion with respect to structure of the show cause notice. There is a confusion with respect to DIN. There's the government says the respect to state government or union territory says DIN is equal to reference number is equal to DIN. Sometimes, certain times they issue notice without DIN. These are all question of law. So you may take it, okay, what is there? They have issued the show cause notice without DIN. What is there? They have issued intimation without DIN, but it is serious consequences as per the constitution. I'm going to enlighten you. I've made arguments in the constitutional courts. I've made arguments in Madras High Court about this DIN issue in detail. I'll explain you how it is affecting the constitution. Very interesting. So, essentially, show cause notice is now issued under Section 73, Section 74, Section 129. 3 services that you have to offer.
All are 74, sir. No 73.
Yes, everything is 74.
Everything is 74. Sir.
Everything is 74. Everybody is malafide in this country except the officers. So, a bona fide, malafide. Section 73, Section 74, Section 129. Let me connect this with Constitution. So, I assure you, after this session, everybody is going to feel confident. And I'm telling you, you will not fear the GST. If you have any fear to GST, call me. I'll tell you how to handle it. You need to be like, see, earlier, so we also have certain times when a client gets arrested or anybody gets arrested. So we also go and meet, we also take them bail and things like that. When we argue on a bail matter, we used to argue on kind of with a lot of spirit and energy. But when you argue on a tax matter, we generally don't do that. Now, in recent time, I started doing it. Tax matter is also like 41A CRPC that the police has to issue. See, intimation is equal to 41A CRPC of the police department 40 summons. When an inspection comes, when summons are issued and the tax difference is more than 5 crores, there's a threat of arrest or not? In fact, the department says, if you don't pay, we will arrest. That itself is wrong. when a department says this, be mindful, they can't do that. Because at the end of the day, it is a tax difference that you have found out. That itself, whether it is right or wrong, we don't know. In a bank, when the audit has happened, they did see what happens. The show cause notice can emerge from three scenarios. One, 73 notice is issued. That is normal. Certain times, audit is taken up by the department. Based on the audit observation, audit officer will refer that to the proper officer. Certain times, audit officer only is a proper officer. The question comes whether proper officer can be an audit officer. Audit officer can be a proper officer. These are all confusion prevailing. I'm telling you. This is literally not a joke. I'll come and explain you all of you when I meet you personally. So, audit gets completed. Audit observations are taken under 74. Not generally under 73. Because for 73, you have the, of course, now the period of limitation has got over. The sole reason why department is issuing 74 notice is not that your assessee is actually a fraud leading to criminality. 74 means that only, no. But it is because of the extended period of limitation. There 3 years, here 5 years. And just because you have an extended period of limitation, you call somebody a fraud. There is a willful misstatement. A wrongful availment of input tax credit doesn't amount to fraud. It is wrongful. The question comes whether it is mistake or error. Certain times, assessee would also not have become. We would have taken a position of law in such a way, it is debatable. I'll give an example of a case, Safari Retreats case, which recently came in the Supreme Court. A Safari Retreats case is a case relating to works contract. I will deal with that shortly before I conclude the session. Safari Retreats case, there is a definition, plant and machinery, plant or machinery. Thin line of difference. Plant and machinery, plant or machinery. So what is defined in the law? What is not defined in the law? Plant and machinery, section 17, subsection 5, input tax credit is blocked like a dam in a river. Input tax credit is like a water. Suddenly you block it with 17.5 under the GST. Safari Retreats case, plant and machinery is defined. Plant or machinery is not defined. Accordingly, Supreme Court allowed input tax credit for plant or machinery. Now, let's assume this position of law came to be enlightened because case reached to Supreme Court. If it had been with the officer, they would have said it's a wrongful availment of input tax credit where supposed to be blocked credit. The loss of revenue to the government, as it is more than 5 crores, then what would have happened? It would have been a scenario where they would have classified under section 74 under willful misstatement, fraud, and wrongful availment, and arrest would have also happened. But Supreme Court came back and said, boss, in GST law, the definition of plant and machinery is different. And plant or machinery is not defined. Accordingly, it is not blocked credit because the construction is for the commercial complex and you can take because it's furtherance of business. Accordingly, it was allowed. It is a law, it is a big subject matter of discussion. Today, the Supreme Court has came out with a stand. Now tell me, the steps that you took under the coercive action under section 74, is it not unconstitutional? Is it not unconstitutional? Is it not affecting the fundamental rights of an assessee? And as Article 19(1)(g), because assessee has freedom to carry on his profession, trade, or business. By ensuring you freeze his bank account, by ensuring you take coercive action, you freeze his bank account, then he's not able to pay the bank loan. He's not able to service his creditors. He's not able to service any of his vendors, neither to his employees. PF, everything goes for a toss. The entire company comes to the ground. The growth story of 30 years is collapsed by the GST department recently. And later point of time, it goes to Supreme Court. Supreme Court gives a standpoint that it is lawful, that the assessee has taken the input tax credit. Then now you cannot rectify every situation that the assessee has faced. In this way, fundamental right is affected. When fundamental right is affected, it is very serious. It is very serious. And Article 14 is affected. Why alone me? One standpoint of law. Why alone for others? Another standpoint of law. Article 14 is affected. Article 19 is affected. And Article 14 is affected. It cracks the fundamental right. Once Article 14 is affected, all the fundamental rights are affected anyway. So 19 is affected. When 19 is affected, Article 21 gets affected. Article 21 is a very, very important article. The Chartered Accountancy course, we focus too much on tax. It focused too much on company law. In fact, there should have been a paper solely dedicated for the Constitution in the Chartered Accountancy course. I'm sure that in future, Chartered Accountancy Institute will have to bring this separately about Constitution. Before we teach tax, we should have taught the students what is a collaboration between the Constitution and tax, what is a collaboration of the Constitution with the company law, what is the collaboration of Constitution with the GST. So arbitrary action of the executive can never be allowed. There are three organs of the Constitution: legislative, executive, judiciary. What I spoke is an arbitrary power. What is not been defined, you assume something. And then you issue notice, and then later I go to the Supreme Court, get clarity after 4 years. But you have frozen my bank account where I have become an NPA for the bankers. Now under the SATHYA Act or under the IBC code, I am suffering a case in the NCLT. Now suddenly the position of law is clear that I need not pay the tax, and accordingly you unfreeze the bank account. Now can I go and completely transform my business? What I suffered, it is not because of my mistake, but the position of law is not clear. And you have issued notice under section 74. And you're asking me to pay for the appeal 20%, 10%. And where will I go and pay 10%? For being a tax collector for the government. What do I do under the GST? I collect the tax, pay to the government. Do I pocket it? No. I am helping the government. For helping the government, my business is collapsed. So this is the fundamental thing. When you receive a notice, ideally you should think in the perspective of the assessee. You should become an assessee. Then think about his position of business. Then you'll get all the answers. Now let us get into the
Whether we get answers or not, we get anxious.
Okay.
Seeing the notices, especially in Tamil Nadu, the notices are running to 40 pages, 50 pages.
Don't worry, sir. Lengthier the notice, more easier to quash.
Sure, sir. Yes, sir.
Okay. So coming back to the point, there are three types of show cause notice which I explained to you. A is the bona fide cases under section 73, malafide cases under section 74, transportation of goods, that is section 129. I would like the members, revered members, to, if you have a Bar Act, kindly go through the Bar Act, and I'm going to read section 73 for the benefit of all the members who are participating. There is a chapter 15, demands and recovery. Chapter 15, demands and recovery. Under section 73, it talks about, I'm going to read it. Multiple times you read, multiple answers you will get. That is the beauty of GST. And multiple questions you will get. And there is no much authoritative commentary that has emerged. So don't worry. Nobody can be claiming authority in this nation on GST, including me, including anyone for that matter, because the law has not evolved. The state of law has not come. I'm sure we'll all be forming part of the hope of Ray to bring the state of law in this country with respect to the GST. If you see, the determination of tax pertaining to the period up to financial year 2023-24, not paid or short paid, or erroneously refunded, or input tax credit wrongly availed, or utilized for any reason other than fraud or willful misstatement or suppression of fact. So section 73 is a section where it covers willful misstatement, fraud, suppression of fact. So accordingly, the notice that is issued under section 73 is a notice under the bona fide cases. Then comes an important section, section 74. You go to the Bar Act and see section 74. Very interesting. Determination of tax pertaining to the period up to financial year 2023-24. Why pertaining to the period 2023-24? Because the Bar Act is updated. Next year when you buy a Bar Act, it will say 2024-2025. So that will be one of the change. Not paid. So you have not paid. You collected the tax, you not paid to the government. That can be taken into willful misstatement, suppression of facts, because you collected, but you didn't pay. Straightforward. Okay. At least I can accept to that extent. Short paid. We don't know why it is short paid, because I have a client who has a demand of about 80 crores purely because at the commencement of GST in 2017, he assumed that the HSN code will be a particular code where the GST will be 12%. I'm not referring to the client name because it's private to my client confidentiality as part of the professional ethics, but I'm trying to indicate the case. It's about a very famous company or top-notch company in the country where I'm appearing for them. It is about 80 crores demand. Because in 2017, the industry had a confusion whether it is 5%, 12%, 18%. Take for example, transportation industry. Still we don't know what are the issues that are prevailing in the transport industry. GTO, GTA, there are multiple issues. So considering the same issues are there in some of the manufacturing electronic companies as well. So 80 crores is the demand. Surely the demand is because instead of collecting 18% tax under one HSN, the client went on to collect under 12% under one HSN genuinely. He has not tried to play around. He tried to collect it. There are some companies who has also done the same. But those companies did not perform well because these are market leaders. Suddenly the GST department comes and says, they issue a notice saying, boss, you should have collected 18% for the past 4 years to 5 years. You have been collecting only 12%. Accordingly, the differential rate of 6%, you have to pay now, and that is about 80 crores. 80 crores. And the client immediately rushed up, and we are now working on it. The question is, here it is not short paid because he collected and he paid shortly. Genuinely, there was an issue of HSN code, and he was not clear under which HSN code it will come. And then he started the billing under that HSN code, and he has not collected anything extra from the customer. What the GST department is saying, in the industry, people are collecting 18%. Why did you collect 12%? Accordingly, 6% you have paid short paid comparing to industry. And they are issuing notice under section 74. Ideally, that should not be the case, because 73 time limit is got over. So this 74 is one section. Now move to section 129, which I mentioned, transportation of goods. Generally, police officers tend to arrest the accused on a Friday. Similar pattern you can see in GST. On a Friday evening nowadays, near the toll, or in the NH, national highways, or even in the city, Friday 5 o'clock, if you see more actively, GST department will be, rowing squad will be going and coming in. And why Friday they are choosing is because if you stop the transportation of goods on the question of e-way bill, rates, whatever, section 129, I'll read 129. You cannot go to the court to the writ petition or to the department. So you are coerced to pay tax. So revenue collection is the mode. So let's assume there is about 2 crore rupees worth of goods or 10 crore rupees worth of goods. Already you are time pressed to deliver the products to the customer. Somehow you secured the contract as an entrepreneur. Now you want to deliver. Now here is one DH department coming and saying, we have seen the joke of Vivek in a film called Sami. I have license card, sir. I have everything, sir. Pulsar bike. எட்டு போட்டு காட்டுறா அந்த மாதிரி GST department is saying, okay, every record is there, but still, why is this problem, that problem? And the assessee is now frustrated, and you call a GST consultant. GST consultant will come and say, yeah, there is a problem. We always assume department is right. Always assume department is not right. Then only you start thinking what to defend. So I compare with the police officer because police also tend to arrest people only on Friday. GST department also stops most of the transportation of goods, not one state. Our transporters, I pity them because they cross different jurisdiction of GST. Everywhere records are being called for. When the GST came, I remember when the former finance minister was there, I had a close interaction with him. Late Sri Arun Jaitley used to always say, I hosted him in Chennai once, in Ramada. He said, when GST comes, nearly 2% of GDP will increase. Yes, revenue to the government is increasing, no doubt. I question whether GDP has increased or decreased. I don't know. Because of GST coming in, because transportation of goods has become tolls, FASTag has come, but slow tag has happened with the department. Slow tag, super slow. You stop the vehicle and then when he will go reach? And by the time he contacts the dealer and he comes to the location and he pays the money, goes to the court, engages a counsel, engages a consultant, and there is no position of law. So many trouble business people face in transportation. So 3 sections which I will be dealing today is 73, 74 and section 129. For the benefit of the members, I would like to read section 129 from the Bar Act. Section 129 under the Bar Act. Section 129 talks about detention, seizure, and release of goods and conveyances in transit. You see, this is now students, when I used to teach the students, and I'm sure that many people, participants, many members here are members of the institute, I used to tell them, யாருக்கும் அடங்காத section will start with notwithstanding. Very simple. If you find a section with a notwithstanding, and the section யாருக்குமே அடங்காது. அப்படி புரிஞ்சுக்கணும் அப்படின்னு சொல்லுவேன் ஸ்டூடெண்ட்ஸ்க்கு. So to understand in that way, section 129 start with notwithstanding. So it will not hear anything. No, it will not hear anything other than the Constitution. Constitution it will have to hear. Because nothing can be beyond a Constitution. But GST law itself is a subject to this section. Can you imagine? So 129, notwithstanding anything contained in this act, where any person transports any goods or stores any goods while they are in transit in contravention of the provisions of this act. What contravention? Tell me examples of contravention. Contravention of these provisions of this act or the rules thereunder. All such goods and conveyance used as a means of transport for carrying the said goods and documents relating to such goods and conveyance shall be liable to detention. Just the way police detains the accused, they will detain the vehicle. And what? Or seizure. And after detention or seizure shall be released. When? That's a question. When will it be released? Look at it. On payment of penalty. On payment of penalty. Equal to 200% of what? Of what I'm asking. 200% of what? The 200% of the tax payable on such goods. You will determine some tax. ஒரு சின்ன ஒரு பேப்பர்ல கணக்கு போட்டு இவ்வளோ பே பண்ணணும் அப்போதான் கூட்ஸ்னா அவருக்கு என்ன ஆகும்? ஆல்ரெடி பிஸ்னஸ் பண்றதே ஒரு பிரச்சனை. இதெல்லாம் எப்போ நல்லா see understand the businessman problem. He is delivering the goods not on cash payment in advance. He is doing it everything for credit basis to realize that 3% margin. Instead of 3% margin, government gets 18% GST. Can you visualize the situation? Who should be more careful? Government should be more careful. Government is doing business with everyone, not businessman. Electronic industry, I deal with one company which is about 1,500 crores turnover. That industry has a very, very thin margin. They manufacture all this mobile charger, Don't think they do big margins, because Chinese company, they move to India. The margins are very less, low cost. Then only they can compete in the international level. Hardly 1% margin, 2% margin. But the GST is 18%. He passes 18%, literally runs a company as a GST collecting company, factory. But whereas for him, it is only 1%. Sometimes it's loss also. When he doesn't recover bad debts. How will he service his loan? Now here is the situation. Exempt goods on payment of penalty equal to 50%. So they will not leave unless you pay the penalty. Is this the right law? You are giving so much powers to the hand of the executive, which is arbitrary. I will come back to this, because we tend to believe the law is right. All that I'm proving, law cannot be right. When first point of confidence that I'm giving you, whenever you're going to take up the matters of the GST, always remember these words which I'm going to give you. A legislation, we can even note down, a legislation which confers on the executive or administrative authority an unguided and uncontrolled discretionary power in the matter of application of law violates Article 14. I'll explain. For the benefit of all of you, it's my duty that I should read Article 14. Because before you see the Supreme Court judgment, it is very important that you get acquainted with the constitutional issues. So then you will understand how can interpret the Supreme Court. It's not the position of law. The Supreme Court is explaining how it is violate your fundamental right, how they are explaining the position of law, the tax standpoint. Now here, Article 14 says equality before law. Everyone is equal before law. Everyone. The state shall not. State means the government or the government of the day. Under state, government is one part, which includes union as well as state government and local authorities. State not denied to any person equality before the law or equal protection of the laws within the territory of India. This article, you connect with the statement I dictated. The statement I dictated, it says legislative giving unguided, uncontrolled discretionary power. When I see Article 2, when I see Section 129, all that I can tell you, the legislation has given an uncontrolled power. What is an uncontrolled power? Violates Article 14. Because you are not stopping every vehicle, you are only stopping my vehicle. What is not applicable to every vehicle should not apply to my vehicle. This should be the pleading by all of you. Next, yet another time, I want my chartered accountants, my fraternity, to write positions of Constitution while you reply to the department. Positions of the Constitution while you reply to the department. Because when we go to the Constitutional Court, they ask you, why you did not represent this department? I said, department don't understand all these things. But department has to understand all these things, because this has to be used sparingly. You can't use it routinely. 129. You see a vehicle, it is in red color, you call him. You see a vehicle, it is in yellow color, call him. You see a vehicle, it is driven by Punjabi, you call him. You see a vehicle, it is driven by Tamilian, you call him. What is this? It is not your discretionary power. There has to be a system in place to bring a coercive action. It is not a surprise check. There is a system established under Section 129. It says any provision of the law. What is the provision of law that I have to violate? What I have violated? So, there are multiple issues surrounding 3 sections. So, now I discussed about the third issue, that is Article 14. Now let me come back to explain section 73. Section 73, when tax is not paid or short paid or erroneously refunded or ITC wrongly availed or utilized due to genuine mistakes only, it can cover only period of limitation. No penalty which is meant to be invoked under malafide cases can be invoked under section 73. A funny thing recently I saw, notice was issued under 74 only, but they have quoted 73. And the entire penalty was exceeding the penalty what should be levied under section 73. Unfortunately, just the way police calls, we all think we have done some fraud. Not necessarily. Similarly, when the GST gives a notice under 73, and you have to check three things. First, you check whether that notice carries DIN, step 1, document identification number. I'll explain that position of law. Second, if it is an intimation, okay. If it is a show cause notice, check whether it is as per the structure of the show cause notice, as per the circular issued by Ministry of Finance for Customs, GST, that is erstwhile service tax, excise, to all the income tax, everything as a structure. This is how the show cause notice has to be issued. It has to be as per the structure. If it is not as per the structure, it is not a valid show cause notice. You can quash it in the court. Why? You can't just say there's a wrongful availment of input tax credit. You tell me what is wrong. போட்டு வாங்காதீங்க. நீங்க வந்து ஒரு wrongful சொல்லிடுவீங்களா? நான் வந்து சொல்லணுமா நான் என்னலாம் பண்ணிருக்கேன்னு? இது எந்த விதத்துல கரெக்ட்? நான் எதுவும் சொல்ல மாட்டேன் boss. You tell me the position of law. Let's assume I have taken input tax credit on insurance of an employee. Question comes whether insurance you can take or not as per section 17(5). But Home Ministry has mandated during COVID time to ensure that all the employees should be given insurance. It is mandated and it is very important for the furtherance of business. There's a position mandated, statutory mandate that leads to availing. Now the question is, if you voluntarily give insurance and then if you have taken input tax credit, then it will be squarely covered under section 17(5). It may be a personal nature, but here it is not a personal nature, but it's mandatory to, you know what happens when you don't have an insurance. It can even cause a going concern issue for the company during COVID time. So accordingly, post-COVID, the position of law has changed with respect to insurance and then input tax credit. Now the department is asking you, why did you avail input tax credit? You tell them very clearly, there is a Ministry of Home Affairs notification that I have to give insurance to everyone, direction. I've given it and then I availed input tax credit. If you block it, you disallow, I'll go to the court. So the point to be noted is section 73 is utilized due to the genuine mistake. Only genuine mistakes. Now coming back to section 74. 74 is a very important section which I already read. I'll just again to summarize and I'll try to reiterate. Where tax is not paid or short paid or erroneously refunded or ITC wrongly availed or utilized due to reason of fraud, willful misstatement or suppression of fact. This is there. What has to be checked? Intention to evade has to be checked. Malafide intention has to be freezed by the department. How will the department fix the malafide intention? By knowing the psychology, ideally. The department is expected to play the role of a psychologist to check whether the assessee, whether the intention is to fraud. Intention is again, I will say he had intention. Assessee will say I didn't have intention. Where benefit of, who will get the benefit of doubt? It is the assessee only. So whenever you receive 74, when you reply to the show cause notice, first thing you will question in the first paragraph while you reply is about the malafide intention. How did you determine malafide intention? You will say it appeared. How it appeared? From a dress code. I hope you saw Vettayan, a film Vettayan by the superstar Rajinikanth. He made a very candid statement. And this is very important because that's how you understand law. And they said, what is the position of law? Just because somebody comes from a poor background, that does not mean he does crime and somebody sits in a building, he does a crime. You can't judge that way. So it has a meaning. Similarly, in GST also it has a meaning. How did you determine I had a malafide intention? You first tell me as a department. You don't have any reason to believe. You don't have any material on record. I know very well you have been sleeping for the past 3 years. Now you suddenly come now, issue notice under 774 because the period of limitation got over under 73. We know your intention. Okay. You don't tell me whether we know you know our intention. So malafide intention is the first thing you will question before you start replying to the show cause notice issued under section 74. Malafide intention, prepare a standard submission. Prepare a standard submission. Take Supreme Court judgments and quote. Adequately, on page, say that I don't have a malafide intention. Submit with the Supreme Court judgment. Don't worry. And the intention to evade tax, 2, burden of proof on revenue. Intention to evade tax, malafide intention is the burden is to prove. Burden to prove is on the revenue, not you. Don't take the effort of proving that you are malafide. ஆமாமா சார் கிளைண்ட் வந்து malafide intentionோட தான் பண்ணியிருக்காரு, கொஞ்சம் பார்த்து please ensure that you reduce the penalty. No need. No need at all. No need to please tell the department I did not have malafide intention in all cases. Let the department come back and say, let them say, how did you have a malafide intention? All these cases goes to High Court and then later point out to Supreme Court, revenue will lose the case. Sure. Because I'm confident because it will hit the Constitution, Article 21. When I said I don't have a malafide intention, that means I'm squarely speaking about Article 21. So I spoke about Article 14 for 129, transportation of goods. Now I'm speaking about Article 21. What does Article 21 speak? So when I'm coming to the Pondicherry brand next time, I'm going to gift every member. Really, I'm saying you have to inform me how many members are there. I'm going to gift everyone Constitution of India. It's my gift for your life. And Article 21 talks about protection of life and personal liberty. I would have read this article for more than 1,000 times. I keep again and again, I'll open and read. Protection of life and personal liberty. No person shall be deprived of his life or personal liberty except according to procedure established by law. Why did you issue 74? What is the end result of 74? If the differential tax is 5 crores, that you determined, you are going to arrest. If you have to arrest, the procedure established by law has to be strictly followed, not loosely followed. No person shall be deprived of his life or personal liberty. What are you trying to do under section 74? You issue a notice and then at the end of the process, malafide intention is fixed by you. You deemed it. I did not even have it. That's my claim. You prove first of all, but you still add a coercive action on me, took me to the prison. Can you do it without a procedure established by law? What is the procedure that is established by law for determining malafide intention? To that extent, that section is unconstitutional. If anybody gets arrested, I am confident that the Constitutional Court will see it very seriously. So understand this. So malafide intention cannot be assumed because presumption of innocence is the essence of the Constitution, spirit of the Constitution. So 73, we will question the procedure. 74, I will question with Article 21. So, if you go for 129, I'll question with Article 14. If all the three can be integrated to Article 14, Article 19, Article 21, golden triangle, defense for GST. Golden triangle defense for GST. This is the method I'm giving to all the members who are participating today. Golden triangle defense for GST. I'm sure you're all really excited to know all these defense points. Why I'm saying this? Because my role comes only in the High Court and the Supreme Court to defend. But the members face the authorities. It's my duty to tell them, you start quoting Constitution when you are representing the matter to the department itself. Let it form part of your submission. Then I will tell later when we go and defend in the High Court. Look, the assessee has submitted. Just the way you expected assessee to know GST, assessee also knows Constitution, which is there for 75 years. We are celebrating 75th year of the Constitution. And the golden triangle will be used. Article 14, Article 19, Article 21. Equality before law. Article 19, freedom of profession, business or trade. I will read that article also. Article 21, affecting the personal liberty. So this is a golden triangle principle I'm trying to enlighten. Let it form part of your submission from the day one when you do it to the department. I'm sure that you are going to do that. Because it will be easy for me to say, I have made this submission before the department. And the department did not understand what is Article 21. Department did not understand what is Article 14. Department did not understand what is Article 9(1)(g). What is affecting my trade or profession. Disregarding this, they have passed the order. It is like a ceiling. Powerful ceiling. Article 14, Article 19, Article 21. Golden triangle for the defense of the GST. Golden triangle for the defense of the GST. I'm thankful to Pondicherry branch because I've done sessions across the nation. But this golden triangle innovation I've done only in this session. I thought, what should I offer? My offering today is the golden triangle defense, which will hold good from the authority to the Supreme Court. I'm not here to say you should read the Constitution, understand the Constitution, go through D.K. Basu, buy books. I'm not saying that. You just quote Article 14, Article 19, Article 21 once for me and get me that. I will take care. In the constitutional courts and the Supreme Court. On any matter, even if it is 10,000 rupees demand, please bring it. Don't pay 10%. Recently, I argued a matter on DIN. And the State Department asked me in the court, what is the demand amount? I said 15,000 rupees. 15,000 only? Boss, department, I said, boss, 15,000. Not 15,000 only. That's not pocket money. It's a client's money. I have not come here for 15,000. I have come here for the position of law, the question of law, pertinent question of law. So that intention is clarified. Hope you understood. It is not that for the high pitch demand alone I will come. I will even come for even 5,000 rupees demand and interest to question that you did not quote DIN. You had all the rights to collect tax, no? That means I also have a right to question the procedure. So in a court, in any reply that you give, two positions. One is question of fact, question of law, mapped with Constitution. Question of fact, I'll come later. What are the question of facts you need to answer? And finally, I'll come to the Supreme Court judgments where they have considered what I said as a serious matter. Let me move to the next important thing. There are 3 stages under the SCM. Am I audible to all of you?
Yes, sir.
Yeah, there are 3 stages. Any doubt? Okay, before I move to the next interesting discussion on the show cause notice stage, any questions here?
Sir, with respect to the DIN, from an income tax perspective, I believe there is a stay given by the Honorable Supreme Court. So, what's the position in GST, sir?
It is actually a stay given for the GST only. Pradeep Goyal's case.
Okay, okay. So,
So
still,
Pradeep Goyal.
so
Yeah, go ahead, sir.
one second, sir. So, since the matter is stayed, lower authorities are not agreeing to that stand, sir. The appellate authorities are not agreeing to that stand that the absence of DIN will invalidate the notice or the proceedings. So, what's your take on this?
See, there is I will give some case laws, and we will, when I'm coming to Pondicherry, we'll have a more discussion in depth. I'll bring the submissions and show you in the PPT. See, Pradeep Goyal's case came in 2022. Pradeep Goyal filed this petition in the Supreme Court. Supreme Court directed all the chief secretary of the respective states to implement DIN. Now you should see, okay, before I get into the show cause notice, we'll have to understand what is the position of DIN. Right question at the right time. DIN is a concept brought by the government. Even Prime Minister Narendra Modi, Honorable Prime Minister Narendra Modi, has said that no department should issue any notice without a DIN. DIN is about tracing the document back and forth. Like, let's assume I issue a show cause notice and you receive the show cause notice either in the electronic form or a physical form. You see a notice and then you should know what is the genuinity of that notice. So what do? You take the DIN and place it in the CBIC website and check, not in the GST portal. Even for an unregistered person, he will not have GST portal access. He will have unregistered person also can get it based on his bank statement. Then where will you go and check the validity of the state notice? You should be able to go and check in the CBSE website. So the purpose of DIN is to avoid is to promote authenticity of the document, transparency of the document. Back and forth, the ASSI should trace. And it should not be, notices should not be used for the purpose of corruption. And accordingly, the assessee, as time and again, has said that, department, that is, Supreme Court has time and again said the respective chief secretary, they have issued direction and mandated that the state should implement DIN. What states have done, without understanding what is the purpose of DIN, what is it actually trying to solve, they went on to say the reference number generated by GST and portal is DIN. Identification number is not equal to reference number. Which reference number am I talking about? It is not that the department should know the authenticity. The document identification is for the benefit of the assessee. Department is saying, we have generated reference number, you accept it. That's not the case. I have to check somewhere. So DIN is mandatory. There is a judgment. I will even quote it. I have recently argued those judgments. Just a second. I'll just indicate to you the judgment. See, the Pradeep Goyal versus Union of India. Observe that the court agreed that it cannot be disputed that implementing the system for digital DIN for all communication sent by the state tax officers to taxpayers and other persons concerned would be in the larger public interest and enhance good governance by bringing transparency and accountability in the indirect tax administration, which are vital to efficient governance. These are all higher words. Considering that in view of the implementation of the GST, as per Article 279A of the Constitution, the GST Council is empowered to make recommendations to the states on any matter relating to GST. The court opined that the GST Council can also issue advisories to the respective states for implementation of DIN system. Further, it also directed the Union of India, GST Council, to issue advisory, instructions, recommendation to the respective states regarding the implementation system of the digital DIN in the indirect tax administration, which is already being implemented in the state of Karnataka, state of Kerala, The court further directed the states concerned to consider implementing the system for digital DIN at the earliest. They never said reference number. Conveniently, the state tax officers have taken a position. The reference numbers are equal to DIN. Actually, that is not the case. The second important thing, based on this judgment, there are many judgments of the respective high courts which has quashed the orders for a simple fact that these orders did not have DIN. These orders did not have DIN. Just a second now. Just a second. I'm opening the arguments which I placed. See, in fact, there is a judgment of the Andhra Pradesh High Court judgment in Sai Manikanta Electrical Corporation versus Deputy Commissioner and others. You can browse writ petition number 12201 of 2024 held that, I read the exact paragraph of the Honorable High Court judgment. We find from the impugned proceeding that they do not contain any DIN number. In view of the circular issued by the Central Board of Direct Taxes, Indirect Taxes, and Government of Andhra Pradesh, the impugned proceeding dated 10/5/2024, recently, May month, issued by the first respondent without generating a DIN number, would have no legs. Look at the wordings. Would have no legs to stand in the eye of law, and the said proceedings are liable to be set aside. What a beautiful judgment. How happy the client would be, especially chartered accountant. Even though the argument would have been done by the lawyer, lesser that the assessee would have met the lawyer, but chartered accountant would have brought the case to the lawyer. And it would have been only an interaction between lawyer and a chartered accountant which would have gone enlightened the client. Because client will not know anything. What he will think, sir, DIN number quote பண்ணா என்னன்னா சார் ஏதோ நோட்டீஸ் வந்திருக்கு சார் என்ன சார் பண்றதுதான் கேட்டிருப்பாரு. DIN இவ்வளவு பெரிய மேட்டரான அவன் நினைச்சிருக்க மாட்டார் அவரு. யாருக்கு இது தெரிஞ்சிருக்கும்? Who would have known this? Only a advocate and a chartered accountant who will discuss this will know. So typically when an assessee comes to me, I always say, bring your chartered accountant. We will discuss and then take it forward. Because the chartered accountant is the master of facts. Lawyer is the master of law. Both should meet to resolve the issue of GST. So whenever we are going to discuss, I would always want the chartered accountant to be present to discuss on question of fact and question of law together. Why is this session becoming very effective? Because you are all master of facts. Now that I am explaining the position of law, you are able to apply in the facts. So now you are thinking in your mind. எந்தெந்த கிளைண்ட்டுக்குலாம் இவர் சொல்றது கரெக்டாக அப்ளை ஆகுதுன்னு யோசிச்சுன்னு இருக்கீங்க. இப்போ நீங்கள் என்ன சொல்றீங்கன்னா ஜூனியர் கிட்ட போயிட்டு ஆர்டிகல் அசிஸ்டன்ட் கிட்ட ஃபைல் எடுத்து பாரு, இவர் சொல்றாரு டின் எல்லாம் இருக்கா இல்லையான்னு பாரு, இல்லைன்னா எடுத்துட்டு வாங்க பண்ணலாம். So Andhra Pradesh High Court says that no legs to stand in the eyes of law and said proceedings are liable to be set aside. Accordingly, impugned proceeding dated 10/5/2000 are set aside. Set aside. However, the department is at liberty to proceed in accordance with law, and petitioner shall cooperate with the department in all aspects in completion of the assessment order, which is stated to be pending for consideration before the first respondent. Look at, for example, another one more case of Andhra Pradesh High Court judgment. It is Ramalinga Ashwara Traders versus Assistant Commissioner, writ petition number 22837/2024. Prima facie, the non-availability of a DIN number is contrary to the judgment of the Honorable Supreme Court in the case of Pradeep Goyal versus Union of India, dated 18/7/2022, and the judgment of the division bench of this court in this case of Mrs. SRS Traders. 1 second, 1 second. Versus Assistant Commissioner in WP number 5238 of 2024, apart from circular dated 5/11/2019, the delay in approaching this court may not be a significant factor, as the order itself would have to be set aside as non-est, because DIN is not quoted. And accordingly, there shall be stay of all further proceedings in pursuance of the impugned order. Reference number. They have said reference number and said there is no DIN. Conveniently, department will say through the standing counsel, reference number is DIN number. But the court of the Andhra Pradesh High Court has said reference number is quoted. They have referred the number and DIN is not there. So accordingly, it was held that the stay of proceedings will happen. Reference number can never be taken as DIN. In spite of the fact circular would have been issued by the respective state government to say reference number is equal to DIN number. So, and the order of stay is subject to the condition that the petitioner deposits 10% of the disputed tax within 4 weeks. So they also asked them to pay 10%. What to do? So they did not deprive the revenue also. But anyway, the pertinent question of law, DIN is not equal to reference number. Reference number is not equal to DIN. I'll add up to your fire of understanding. In Madras High Court, Honorable Madras High Court in Mrs. Ericsson India Private Limited versus Deputy Commissioner of Customs. Even Customs Department DIN is mandatory based on the circular issued on 5/11/2019, 23/12/2019. The board have not been brought to the notice of the Honorable Supreme Court. The thrust of the exercise is to ensure that every communication issued by the state, including emails, must contain an authorization. The move is a progressive one backed by the avowed objects of transparency and accountability, the crying need of the day. Accordingly, in light of the discussion above, impugned communication dated 4/8/2020 is set aside and that this writ petition allowed, no cost connected miscellaneous petitions are closed. It is a Madras High Court judgment. I explained about the Pradeep Goyal's judgment. I explained about 2 Andhra Pradesh court judgments. One without DIN, one without DIN and reference number. Second, with reference number, but that is not a DIN. Third, I also told DIN is important for customs. Now you are enlightened, you are packed with defense. So hereafter, moment you receive the notice, before you check the position of law, what question of input tax credit, what is the notice, what you will check?
Availability of DIN.
If DIN is not there, please call me. I'll tell you what to do. I am there to help you. With respect to what? Giving a defense to the department. Otherwise, do one thing. Allow the department to issue all notices without DIN. Then come to me. Allow the department to do the mistake. Let them do the mistake. I'm able to say this with a lot of conviction because from 2017, I'm training the department officers. I keep saying them, follow the procedure of law, follow the procedure of law. So it is a very important thing that I've discussed today, that is about the DIN, and we will further advance our discussion. So now that you know whether if you receive SCN, first thing you will check as per the Supreme Court judgment, Pradeep Goyal's case, whether DIN is there. What are the 3 stages of the SCN? The government cautiously, for ensuring fair collection of taxes, they've introduced 3 stages of SCN. Pre-SCN stage, SCN stage, post-SCN stage, post-SCN stage. In the pre-SCN And my dear members, it is just not the DIN only for SCN. All communications of the department, including inspection. When they come for inspection and give you an inspection report, it should carry a DIN. A summon is issued, DIN. You are called for to the personal hearing, DIN. In fact, my good friends in Madras High Court call me a DIN advocate. And my juniors, once they were taking adjournment on the state advocate, state standing council, said it is a DIN advocate's case. So you should understand what kind of arguments I would have had putting up the procedure of law with respect to DIN. I firmly believe that the founding fathers of the Constitution were very clear that the procedure is very important. You tax, that's not the issue. I'm not asking you, I'm not saying every assessee is a saint. I also know. But there is a method. There is a method. That method procedure has to be followed strictly because you are executive. You can't exhibit arbitrary discretionary power. A good case also, the department is losing, you know why? They overdo things. They cinematize. They dramatize. In one of the, just to lighter vein, one of the client went to a personal hearing. And the officer has said, sir, இது தக்காளி வாங்குற மாதிரி தான். தக்காளி 100 ரூபானா நீங்க 100 ரூபாய் கட்ட வேணாம். ஒரு 50 ரூபாய் நெகோஷியேட் பண்ணி கட்டிடுங்க. இப்படியா நீங்க ஜிஎஸ்டி இம்ப்ளிமெண்ட் பண்ணுவீங்க? இதுவா ஃபவுண்டிங் ஃபாதரோட விஷயம் இருந்தது. எஸ்எஸ்சி வந்து சொல்றாரு, தக்காளி எனக்கு புரியல, ஜிஎஸ்டிங்க இது, தக்காளி கிடையாது இது. தக்காளி 100 ரூபாய் சொன்னா 100 ரூபாய் கட்டுவீங்க, நீங்க நெகோஷியேட் பண்ணுங்க. You can definitely bring down the power to reduce the penalties there under section 73 of the office. I will read it in detail because we are just starting to interact. So, pre-SCN stage, what is this? SCN stage, what is this? Post-SCN stage, what is this? We all believe that SCN means only one stage. Actually, no. There are 3 stages in SCN. And pre-SCN consultation, part A of form DRC 01A. Form DRC 01A. I'm very happy to see the members traveling, and I remember my chartered accountants days. We used to prepare for the examination, rushing in the bus, and then at the last minute we prepare. I can see that now with the members joining from car everywhere. I appreciate. So DRC 01A. Optionally effective from 15/10/2020. So they brought this concept. Then demand accepted, payment of tax in ZR3. If you accept demand, poor man has accepted the demand, I would say you should not have. And paid their money, DRC 03. You can pay the tax. Then you have intimation, acknowledgement of payment to be issued in DRC 04. The government has to issue the acknowledgement of receipt. If they don't receive also, you come to me. Again, this is the procedure. You can't collect and keep quiet. You have to issue the intimation of payment. How do I know where did it go? Then closure of proceeding, no SCN after that. Bayam putti paakadhu, adhan pre-SCN. Katriya, okay. Kaditingla, okay. Katna, receipt kuthira, close பண்ணிக்கோங்க. Pre-SCN. Pre-SCN வராத மாதிரி நினைச்சுக்கணும் நீங்க.
இப்ப கட்டினா இவ்வளோ, SCN கொடுத்ததுக்கு அப்புறம் டிமாண்ட் இவ்வளோ.
கரெக்டா சொல்லியாச்சு. இப்ப கட்டா அந்த சிவாஜி படம் மாதிரி தான். சிவாஜி ரஜினி படம், சிவாஜி படத்துல வந்து பாத்தீங்கன்னா இப்ப கட்டினா எவ்வளோ, அதுக்கப்புறம் கிடையாது எதுவுமே அந்த மாதிரி. ரெண்டாவது SCN ஸ்டேஜ், இஷ்யூ ஆஃப் SCN அண்டர் செக்ஷன் 73/74. 74/73 வராது pre-SCN ஸ்டேஜ்ல. DRC 01A வரும்போது you don't know whether the proceeding will be under 73 or 74. விட்டு பார்க்க வேண்டியது. நீங்க GRC 01A நீங்க கொடுங்க, கான்ஸ்டிடியூஷன் பார்ப்போம் 73 கொடுக்குறாரா 74 கொடுக்குறாரா. உங்களை கூப்பிட்டு கேட்பார் 73 74 உங்களை தான் கேட்கணும் ஆக்சுவலா, அவரா கொடுக்க கூடாது. ஏன்? உங்ககிட்ட பேசாமையே உங்க இன்டென்ஷன் எப்படி கண்டுபிடிப்பாரு? அவர்னா அஸ்ட்ராலஜரா? சோ அண்டர்ஸ்டாண்ட் பண்ணிக்கோங்க. உங்ககிட்ட பேசாம, உங்களோட உரையாடாம, உங்க இன்டென்ஷனை எப்படி கண்டுபிடி? இன்டென்ஷன்னா என்ன? இப்போ என்னோட இன்டென்ஷன் என்னவா இருக்கு? உங்களால எப்படி புரிஞ்சுக்க முடியுது? I want to empower my community of people, that is chartered accountant. I want to bring that rich knowledge and offer you. That is my intention. So you are able to find this intention because I'm interacting with you and we are engaging ourselves. How did you find my intention? Bona fide or mala fide? Without even meeting me. There is a wrongful availment of tax for somebody else who issued 73. Same wrongful availment 74. And you came to know that wrongful availment is there. You are watching closely and caught my vehicle. எப்படி 74 கொடுத்துட்டு வேற செய்யறாங்க. வெஹிக்கிளும் நிறுத்தியாச்சு, என் பிசினஸே நிறுத்தியாச்சு. எதுக்கு? வீட்டில் உட்காந்துக்கணும் நிம்மதியா, எதுவுமே செய்யாம. So 73, 74, how did it remain? So the question comes, service of SCN to the assessee, very important. Service. So whether the next question comes, whether uploading SCN online and not intimating you, whether it is principles of natural justice is violated or not. Accordingly, the question of SCN, service of SCN comes. Adhu vechum question pannalam. Serving. You all remember your age-old classes of our senior members. T.N. Manoharan sir, Bhupati sir, maybe some super seniors in our session, Upadhyaya sir. They used to talk about serving and issuing in income tax. I have enjoyed those sessions with the senior members. And what we are today is because of the senior members. The knowledge they provided, the opportunities they provided. So, Bhupati sir, everybody used to mention all these things in their classes and then their deliberations. We used to run and then, those times no online, nothing. We have to rush to the institute, Brahmaya Hall. Listen to them. They will say, service, serving a notice, RPAD, registered post. Now, what has happened for serving? You upload and never call assessee. Then say he has not attended the hearing and you confirm a demand. This is what is the intention of the law. It can never be. That can also be questioned in the SCN stage. Then post SCN stage. After you issue SCN under 73 or 74, இப்போ பிரச்சனை என்னன்னா SCN கொடுக்கும்போது 73, 74 சொல்றது இல்லை. And the formula, if you see, it will say 73/74. Later they will strike 73 and then say it is 74 proceeding. What a beautiful idea. இது எப்படி இருக்குன்னா எக்ஸாம்ல வந்து ரெண்டு ஆன்சர் எது கரெக்ட் ஆன்சர் நீங்க கரெக்ட் பண்ணிக்கோன்ற மாதிரி இருக்கு. Abuse of power, discretionary power, executive power, arbitrary. These are all arbitrary. What is arbitrary? It is against the fundamental right. It is fundamental right. Next, basic checks. Post SCN stage, you have to do SCN issue within a time. Calculate, take a paper, sit with your article assistant, sit with your juniors. SCN in the date, in the data, extension period, fresh notification, எல்லாமே consider பண்ணுங்க. Have a discussion with the members within the fraternity, within the time. SCN is issued by proper officer. Time, idam, porul, eval. Apply that. Who has to give, who should give, what time they should give, everything matters. Time, proper officer, and valid modes are WhatsApp service of SCN cannot be permitted. Show cause notice cannot be discussed over phone. Personal hearing opportunity has to be provided. And according, objections to be filed in Part B of DRC 01A. Opportunity when sought or negative order is contemplated or to be passed after considering the submissions made. I was arguing a matter. So first is DIN. The department said, sir, first is DIN, no? Now I am coming to the structure of the SCN. I will talk about it now. I will take some time. Is every member feeling interested, or should I somewhere hold the discussion and then later we'll come and meet you at Pondicherry branch?
Yes, sir. Go ahead, sir.
Thank you, Anjit Kumar sir. So just wanted to check everybody is active. Hari Govind sir, Soumya ma'am, Prabhakar ne, Balaji sir, Hirendra sir, Padmashri, Gomati Tanikasalam. I hope everybody is listening. Okay, right. So what happened? This first is the DIN. I spoke about you. I enlightened you the position of law. Let me now come to SCN. Show cause notice has to be as per the structure provided by the department. That is Ministry of Finance. First thing that the department will say, circular is binding the department and not the assessee. Don't ever believe it. This has been a part of our examination question in CA final. In our assessment procedure, Sun Engineering case, Dampur Shubhanmul's case, all those things we read and wrote in the examination. Sun Engineering case, doctrine of telescoping, and all those things. But the show cause notice, when I said it has to be as per structure, you know what department replied? Department said the GSTN doesn't allow more than 600 words. Wonderful. Not allowing itself shows that your proceedings are unconstitutional. Why? As per Constitution, basic structure of the Constitution of India, as per the Keshwananda Bharati versus State of Kerala, which is a very, very important judgment of the Supreme Court in 1973. 24th April 1973. It's a very, very important landmark day of India, 1973. Under Keshwananda Bharati versus State of Kerala, in the basic structure of the Constitution of India, it is the rule of law. Rule of law is not rule by law. There's a difference. Rule of law is Constitution is supreme, law is supreme. No man is supreme, not Prime Minister, President, Chief Minister, no one. Everybody has to be below, will be below the Constitution of India. Shall be, not maybe, shall be. Directed to be, mandatorily. It's a rule of law. Now, basic structure talks about rule of law. Government is talking about rule of technology in the robo Yendran padam mari. Green chip போட்டு GST கொண்டு வர வேண்டியது, ரெட் சிப் போட்டு ரோபோ அப்படின்னு சொல்லி எல்லா எஸ்சியும் கொடுக்க வேண்டியது. பட் வந்துட்டு ரூல் ஆஃப் டெக்னாலஜி, ரூல் ஆஃப் லா, ரூல் ஆஃப் டெக்னாலஜி, ரூல் ஆஃப் லா, ரூல் ஆஃப் டெக்னாலஜி. A country cannot be ruled by technology. Basic structure of the Constitution of India is rule of law. You have cracked the basic structure by saying rule of technology. A.V. Dicey, one of the famous constitutional expert, who has given the book called Introduction to the Study of the Constitution, whose ideas are the rule of law under the Westminster parliamentary practice, which was evolved in India by the founding fathers of the Constitution. And the rule of law is very interesting to say. You can't say my GSTN portal doesn't allow, accordingly I cannot draft the rule of law and present it to the assessee. And accordingly I am not able to follow circular issued by the department, SCN. No, I said, look, rule of law, rule of you spoke about rule of technology, it is rule of, against rule of law. Now you have to establish rule of law. He says there's no space. I said technology should be subservient to the department. Department cannot be subservient to the technology.
Vice versa. So it is true, sir. We are not able to upload all the relevant evidences to the department because there is a restriction on size.
Exactly. This has to be questioned. You can't restrict the size. When you restrict the size, how can I submit? You increase the cloud space. It is a return on investment. How much collections you are making? Finance Minister says we are collecting 2 lakh crores, 3 lakh crores, 4 lakh crores. We are all celebrating GST collection. In fact, we should celebrate income tax. Now we are celebrating GST. And when you celebrate GST collection, it is regressive model of taxation. When you celebrate income tax, we celebrate progressive base of taxation. If we are celebrating GST, that means society is moving towards regressiveness and not progressiveness. Instead, if you say GST collection has increased so much, proportionately income tax collection has increased so much, then I would have appreciated the fact that common man is given the liberty to reduce its tax burden. Middle class, the tax burden. Just by providing ATC, ATD, it's not going to be sufficient for me. Now, they are contemplating to bring GST for second-hand vehicles. They're contemplating to bring GST for multiple other products. When they will bring for the petrol and diesel, we don't know. And one thing that is kept out of GST is a famous product that is spirit, alcohol. At least that is kept out of the GST. If you have to bring alcohol, you know what? You have to pass constitutional amendment. Can you imagine? One product which requires constitutional amendment today is alcohol, not milk. So, the point to be noted here, is the SCN stage. There has to be a structure for the SCN. If the structure of the SCN is not followed, there are many Supreme Court judgments and the High Court judgments which insist on structure of the show cause notice. So we can question to that extent. It should go into your submission in the post-SCN stage, not before the SCN stage. Strategy of defense. Don't do it in the pre-SCN stage, this submission alone. I'm sure the department is not viewing this video. Thankful, they should view also. There should be some intelligence who should come and view this session. At least they will follow the SCN structure. I'm telling you, they can't follow because GSTN doesn't allow. There's a restriction on words. That is not my problem. If you go check the circular issued, I'll just highlight the circular of the SCN, the circular number, so that you can note down and you people can go and verify the circular. It is circular number 1053/02, 2017, issued on 10th March 2017, which talks about structure of the SCN in para 2.2 of the circular. Structure of SCN should ideally comprise of the following. Though it may vary from case to case. Introduction of the case, legal framework, factual statement and appreciation of evidences, discussion facts and legal framework, discussion on limitation, calculation of duty, other amounts due, statement of charges, authority to adjudicate. Do you find anything in the SCN?
Now they have made it even simpler, sir. As per annexure, that's all. Only amount is there.
In the annexure, they will say this amount. This is the arbitrary power of the executive. We should not leave it lightly. See, the difference between professionals, like, see, in compliance, we agree. In litigation, we disagree. Here is a deadly combination of compliance and disagreement today in this session. What you thought everything is normal, I'll always say it is abnormal. Don't normalize it. Somebody told me, sir, why are you so furious about these issues? Didn't only not quoted, no. Why is the department so furious? I only paid little tax. You are furious because you gave the notice. I can't say that you have not followed this DIN and SCN. I don't have voice. I am not furious. The Constitution of India is furious. Constitution of India is so strong about the procedure prescribed by, established by law. They have not said except GST. They said it for all the laws. Now, third important enlightenment to all of you. There are many things. When I come, we will have a personal decision. Today, I'm just highlighting what are the issues that we can address together. We have to move the ship of controversy together. Not one individual cannot transform the space of this GST. for optimal distribution of work. So now the question comes, sir, the circular, whether it is a law. Circular, they say circular is only binding the department. Binding for what? Binding for your duty. Anything issued by the department is a law. Sir, how do you say? Article 13. Take your constitution. That's what I'm going to give to you all the constitution next time, the premium edition. Article 13. Laws inconsistent with or in derogation of the fundamental rights. It says, Article 13(3), Clause 3. In this article, unless the context requires, law includes any ordinance, order. It does not say government order. Don't assume government order. Comma, bylaw, comma, rule, comma, regulation, comma, notification, comma, custom, comma, or usage in the territory of India, the force of law. It ends with the force of law. All this having the force of law. It need not be a law. So considering it, the circular is a force of law. On what? Not to the assessee, but to the department. But the assessee has the right to question why this force of law has not been implemented by the department. ஒரு கேஸ் நிக்காது டிபார்ட்மெண்ட். இது சர்க்குலர் ஃபாலோ பண்ணா அது என்னோட இஷ்டம் எப்படி சொல்லலாம்? அப்ப எப்படி சொல்லலாமா? நான் கொடுத்தா ஜிஎஸ்டி அசெசி, நான் லா ஃபாலோ பண்ண மாட்டேன்னு சொல்லட்டுமா? You want me to follow the notification, you will not follow the circular. How is it right? Circular is a law. If you violate a circular, then you violate the law. If you violate the law, you essentially violate fundamental right. When you violate the fundamental right, you violate the Gondal triangle. Article 14, 19, 21. Finished. Case is over. So now, this is about the fifth controversy which I spoke now. All simple. நிறைய இருக்கு இன்னும். Thousands of judicial precedents I have noted. So I can take classes for 1 year continuously. அவ்வளோ இருக்கு ஜிஎஸ்டில. Thousands of controversies in the GST. In fact, the arrest provision under the GST itself is unconstitutional. There cannot be arrest provision at all. The arrest has to happen only as per the BNS, Bharatiya Nyaya Sanhita, or Bharatiya Nyaya Suraksha, BNSS. That is your criminal procedure code, BNSS. But whether GST officer is a police officer, whether it is a judicial proceeding or a criminal proceeding, what proceeding is that? Whether he has to issue 41A CRPC or equal to 41 CRPC under the BNSS. இதெல்லாம் தாண்டனாலும் எவிடன்ஸ் ஆக்ட் அஃபெக்ட் ஆகும். Any statement you give over the police station or the department is not going to be held as evidence. Jolly. So it has to cross many milestones in case of the proceedings. So confidently, all the members should handle. We have to move the ship of controversy, ship of arbitrary powers of the executive. Together, we have to push the ship slowly, steadily, with a lot of confidence, only on the Constitution of India. Coming back to the key statutory provisions. For optimal distribution of work relating to the issuance of show cause notice, orders under section 73-74 monetary limits for different levels of officers of the central tax has been prescribed by the CBSE for circular number 31/5/2018, dated 9/2/2018. I repeat, circular number 31/05/2018 and dated 9/2/2018. The entire reason I'm not sharing any PPT because in the online mode, I'll become small and the PPT will become big, so you will not be able to have interest. You will not look at the articulation. But I'm trying to provide the circular numbers so that you understand. See, the central tax officers who is authorized to issue the show cause notice is that monetary limit of the amount of central tax, including cess involved, is not exceeding 10 lakhs. Then it is superintendent of central tax. Monetary limit of the amount of integrated tax including cess involved, not exceeding 20 lakhs, again, superintendent of central tax. Monetary limit of the amount of central tax and the integrated tax exceeds 20 lakhs, again, superintendent of central tax. Like this, based on monetary limit, 3 offices are given the power. Superintendent of central tax, deputy assistant commissioner of central tax, then additional or joint commissioner of central tax. Now, my dear members, moment you receive the notice, you see whether there is a DIN, second, whether it is as per the structure of SCN, see whether it is issued by the proper officer. The question comes, whether JC can issue the notice that need to be issued by the superintendent of central tax. Answer is no. If that answer is no, whether superintendent can issue the notice that need to be issued by the JC. Answer is no. Why? Neither the subordinate powers can be taken by the superior. Very simple. Can Prime Minister be a VAO? He can't. Only VAO can do the work of the VAO. It is a delegated legislation. A collector cannot go and issue notice to another district. VAO, powers which are vested with the VAO, the collector cannot take it. The separation of power is the essence of the Constitution. There's a doctrine of separation of power. If the superintendent issues a notice instead of joint commissioner or assistant commissioner of central tax, then what will operate there is doctrine of separation of power. When the powers are separated, you can't take over that power, neither you can subordinate that power. You got the point. So check who has to be issuing the notice, and accordingly you can look at what difference points you can take with respect to the proper officer. When proper officer of the jurisdiction has to take, you cannot have a cross jurisdiction. So there are some very interesting sections. Section 169, subsection 1. I'm not going to read the Bar Act, but I just wanted to highlight about section 169, subsection 1, which talks about hand delivery to the assessee or his authorized representative holding a valid POA, the show cause notice. Then section 169, subsection 4, uploading at the common portal. Section 169(3), email address as provided at the time of registration or amended from time to time. Section 169(2), registered post or speed post or courier at the last known place of the business or residence. These are all the modes of serving the show cause notice. Then comes validation of SCN. I'm going to give a case study. There is a company called ABC Limited. It's a typical my client's case, but I don't want to provide the name. ABC Limited was issued an SCN by the superintendent of central GST for wrong availment of ITC. CGST 12 lakhs, SGST 12 lakhs. Is the SCN valid? 12 lakhs CGST, 12 lakhs SGST. Superintendent has given this notice. So that in aggregate, see the very important point, superintendent central tax. So now the question is whether 12 lakhs is exceeding 10 lakhs. Answer is yes. Individually also it exceeds 10 lakhs. In aggregate it exceeds 20 lakhs. So let us analyze this situation. Accordingly, if you see, no, it is not valid. It's not a valid SCN because the maximum threshold limit for the superintendent to issue note SCN is rupees 10 lakhs. You got it? I told about the doctrine of separation of powers. In the present case, the SCN covers a total demand of INR 24 lakhs, which is beyond the jurisdiction of the superintendent. Therefore, the said SCN can be challenged before the High Court through a writ petition. Writ petition is what? Writ jurisdiction comes under Article 32, which is a fundamental right again. Article 226, which is a constitutional right again. Writ petition is not some petition that you file with the High Court. It is to reinstate the fundamental right, the golden triangle, which we innovated today. So the Allahabad High Court in Mansoori Enterprises versus Union of India has allowed the writ petition challenging the jurisdiction of the superintendent based on monetary limits. Okay, let me give you one more case study. Same ABC Limited. ABC Limited paid tax after the due date of payment of tax. Okay, they paid after the due date. No problem, they did a mistake. The SGST officer issued a show cause notice in form DRC-01, demanding interest for delay in payment of tax. Superb, no problem. I accept. I paid tax late. Okay, I have to pay. No problem. Did you issue the notice properly? Is the question. நான் தப்பு பண்ணிட்டேன் நீ கரெக்டா பண்ணியா? அதான் question. அதான் defense point. Here, is the SCN valid? No, it is not valid. Why? For recovery of only interest, the proper officer required to issue an SCN in DRC-07. You can't issue DRC-01. தப்பான ஃபார்ம். எவ்வளவு மைன்யூட்டா நீங்க பார்க்கணும் பாருங்க. Accordingly, in Raj Kamal Builder Infrastructure Private Limited, Union of India, the Gujarat High Court held that interest cannot be demanded by sending out a notice using DRC-01 for raising the demand of interest. Form GSTR-07 is required to be issued for raising the demand of interest alone. Next question. Again, my client's case. Proper officer issued SCN. He issued a SCN. Proper officer issued SCN under section 74 for financial year 2017-18. 18-19, 19-20 as a single SCN. Is the SCN valid? Single SCN for all 3 years. சூப்பரான ஆஃபீஸர். இந்த மாதிரி ஒரு ஆஃபீஸர் வந்து கரெக்டா அப்படின்னு பார்த்தீங்கன்னா லக்கியா அது கரெக்ட் ஆயிடுச்சு. அவருக்கே தெரியாம கரெக்டா பண்ணியிருக்காரு. Yes, it is a valid SCN. For all the 3 years he can give. GST law does not restrict issuance of SCN for multiple years as one SCN. That does not restrict. The question comes, இப்ப மாட்டுவாரு. புத்திசாலித்தனமா 3 கொடுத்துட்டாருல. ஆல்ரெடி வேர்ட் ரெஸ்ட்ரிக்ஷன் இருக்கு. SCN ஸ்ட்ரக்சர் இருக்கு. ஒரே SCNல எத்தனை நீ ரெஃபர் டு தி அனெக்ஷர், ரெஃபர் டு தி அனெக்ஷர், ரெஃபர் டு தி அனெக்ஷர்னு கொடுப்போமா? அப்போ SCN ஓட ஸ்ட்ரக்சரே ஃபாலோ பண்ணல சர்க்குலர் படி. You got it, my dear members? Section 73, subsection 4 of the CGST Act, where SCN has been issued for 1 year on some grounds, a statement can be issued on some grounds, same grounds for other years. It was held in Titan Company Limited as a joint commission of GST. Bunching of SCN for multiple years under section 73 is invalid, where it exceeded the individual limitation period of each year. Look at this. For 2017-18, the limitation period exceeded. Here is an officer who issued the show cause notice in single notice with 2017-18. All the 3 years will become invalid. We have this concept called Tuklak Darbar. ஏதோ இன்டெலிஜென்ட்டா பண்ற மாதிரி பண்ணி மொத்தமா வந்து சொதப்புறது. ஃபர்ஸ்ட் SCN ஸ்ட்ரக்சர்ல இல்ல, டின் இல்ல. சரி கொடுத்துதான் கொடுத்தீங்க 74 73ல 2018-19 கால டைம் இருந்திருக்கும். You gave it in one SCN. Because of one SCN 17-18, then the entire proceedings became invalid. Look at the beauty of law. Then why are you afraid? Why are you finding it difficult to handle? It's easy. That's what I'm trying to prove time and again. So there are multiple case laws which I have drafted, more than 50 to 60 situations, to make you think and go back today from your Coutrallam after a nice vacation, and you're going to get a year end. Just ask your juniors to check all these facts while you go back from Coutrallam to Pondicherry or wherever. Just see what all the cases we can apply this. And if you want any clarification, I'm always there from the fraternity. Authorization of officers under GST. Who are all the proper officers? Now I'm going to discuss that. Proper officers, authorization officers are in fourfold. Assigned authority, central officer as proper officer, SGST officer as a proper officer. Power to issue orders, CGST order plus SGST order plus IGST order and section 4 of the IGST order. CGST order, SGST order, IGST order, section 6 of the CGST order and 4 of the IGST Act. Proceedings initiated. SGST officer, no proceeding shall be initiated by the CGST officer on the same subject matter and vice versa. If SGST takes up, CGST cannot issue. Of course, there is a cross empowerment. It is sparingly used. But even cross empowerment, I can question through various constitutional provision. Even if it is a cross empowerment. The question comes for cross empowerment after the proceeding gets over in state, whether you have a time limit to open up. If it is 74, then double jeopardy. As per Article 21, it is prohibited. You can't bring a double jeopardy. Ideally, Section 73 only will be applicable. So 73 time limit got over. So again, there is a defense point to that. So then comes rectification, appeal or revision. Any rectification, appeal or revision against an order passed by the CGST officer shall not lie before the officer appointed under the SGST Act. So this is a very important, tricky situation. Why? There is no rectification, appeal or revision before the officer appointed by the SGST. It's a tricky situation. We will discuss it in length later point of time. Cross empowerment powers. Cross empowerment powers are criteria of division of taxpayer between the center and the state. The GST Council, via circular number 01/2017, has provided the guidelines for division of taxpayers between center and the state to ensure single interface under GST. Taxpayers below 1.5 crores or of turnover. This is squarely because of the efforts taken by the Tamil Nadu government. At that point of time, the person who went to represent in the GST Council is Mr. Maafai Pandeyarajan. You may be aware of him. He went to represent the GST Council. So after he met the GST Council, he came out and gave an interview, if you remember vividly, about this cross empowerment. Recently also I met him while I was traveling. We traveled together. At the time I was actually speaking to him. I said, sir, you were the person first to speak about cross empowerment in the entire nation. What is cross empowerment all about? The cross empowerment is a situation where taxpayers below 1.5 crores of turnover, administrative, where it is 1.5 crores turnover, 90% with state and 10% with the center. Tax above 1.5 crores, 50% with state, 50% with the center. Administratively. So that means state will have more power with respect to the adjudication of the matter. With respect to turnover less than 1.5 crores. The question here is, why is the state deprived? Higher turnover CGST, lower turnover state. This itself is a question which is pending for a controversy. Why? I'm asking a simple question. 50-50 is okay in any situation. Why, if it is less than 1.5, state has to be burdened? Because revenue will not come more, so center cannot handle. You want revenue, but state has to work. Pushing the lower revenue matters to the state and higher stake to the center, which is not as per Article 14, between the center and the state in the federalism. Nowhere it is said in the constitution that the state is lesser than the union, neither union is higher than the state. Never the state is subordinate to the union, except to the matters. There's an exclusive power of the union list, exclusive power of the state list. In fact, in the concurrent list, if the state has passed the order, so the state has passed a law, if there's a central act also on the same subject, state law will prevail over the center. Doctrine of repugnancy. So in federalism, state has more power. Of course, controlled by the unitary feature like governor and president. You know the story of governor and... So interesting to see all this development happening. So there are multiple case studies. In the paucity of time and detailing, I'll do it later. Typically, the notice issue of notice procedural aspects are denial of ITC on account of cancellation of registration, certificate of the supplier. Second issue that comes is denial of ITC due to mismatch between GSTR 3B and GSTR 2A. This is a very tricky situation. Only accountants can answer this. Unfortunately, many, see, I can understand this because I am from our fraternity. Generally, there is a difference between 2A and 3B. 3B you would have claimed input tax credit, but in 2A, the respective supplier would not have paid the tax. Accordingly, in 2A, you will find the lesser ITC. The question comes, how can you be held responsible for the supplier not paying? You can't go and coerce him to pay. And the difference between 2A and 3B fundamentally has to be examined by the assessee, and department has to be empathetical about this. Detention of goods due to typographic error in e-way bill. Incorrect vehicle type, rest details were incorrectly filled. In detention of goods due to typographical error in the e-way bill. Let's assume some vehicle you took, it got punctured. You shifted the product immediately. Let's assume some packaged food. You move to another vehicle, the e-way bill will have it, and you try it and write it. Now the question comes, GST authority holds you. Why is the vehicle number wrong? Typographical error. Or because of the situation is not addressed in the law. You got it or not? There are multiple extraneous situations which is not, GST law is not empathetical. So, levy of GST on notice pay recovery issues, denial of ITC on expense incurred towards CSR. These are all upcoming issues. Denial of ITC on motor vehicles used for demo purpose. I'm just giving you some areas of dispute. These are all the cases I wanted to discuss. But you'll have less time, but I'm indicating maybe in future. Secondment of employees. So when you draft SCN, what to be done? So I told you the position of law, I told you proper officer, I told you some controversies surrounding. How do you draft? A, document the complete facts. You become the master of facts. No one can replace a chartered accountant in facts. In fact, when you get your facts right, certain times you need not worry. You bring the facts and then a law can be applied easily. But if you're not able to articulate the facts of the claims, then we will not be able to freeze what law could be applied there, what constitutional provisions are violated. So become the master of facts about his business, value chain, where is the GST issue exactly. There is a pipe, there's a water leaking. You should know where is the water leaking to ensure that further issues doesn't come. Either you cut the pipe and then join with the patch, or you see that you put a glue, see that the water doesn't get out. Similar is the situation of the GST. You become a master of facts. Law is a byproduct. You may be a master of law, but you don't understand the facts. You can't apply. So we have to come together. The master of facts and master of law, it's a deadly combination to defend any case. Any case can be defended. That's my humble submission to all of you. Any case, don't worry about the case. Any case can be defended. It's an outright commitment because any case can be defended because the constitution comes into picture. Arbitrary powers comes into picture. Second, address all the issues raised in the SCN point-wise. You should address all the issues in the SCN point-wise. So SCN you would have given clumsy. Segregate the issue, address those issues point-wise. I will give an example how I have addressed. Reply should be crisp and to the point. Straight to the point. Quote the judgments which are relevant to the matter and preferably higher forum. I told you, Supreme Court, Constitution, rule of law. Then do not use the words which are harsh. Use constitutional words. How can you issue this notice? How dare you can issue? Don't use that kind of words. Use constitutional words, legal words. words which you will be using in the court, use in the SCN itself. Prayer clause to be meticulously drafted. Your prayer clause should be meticulously drafted. Prayer is very, very important. So master of facts, master of law, master of prayer. Quash the order because DIN is not quoted. Structure of the SCN is not there. Proper officer is not issued. Time limits are there. Limitation issues. Quash. Ensure that the order is invalid. Make sure that the order is invalid and quash the proceedings. Clearly mention all the prayers like personal hearing also. Like if you want personal hearing, mention the prayer when you reply back to the SCN. Don't close. If you may require any more information, please let us know. I am ready always for personal hearing. Put it in bold. Don't say you are convenient for a personal hearing. No. Don't say if you may call, I'll come for the personal hearing. Just say I'm available for personal hearing. Finished. There is a reason why I'm saying this. You are available. The question is they are available. 24/7 you are available. That itself shows that you are not with a malafide intention. I'm not running away from the proceeding. I'm ready to face you eye to eye to explain. Where is the question of malafide intention? You can break the malafide intention through your constitutional provisions. So 74 is the biggest challenge. So I tried to cover most of these matters. I'll just show you. One second. Huh? I'm just opening my submissions. Here's a case of my client. I'm not referring the client name, but I'll provide you some scenarios and I'll tell you how to answer. The first defect that they have raised as part of my show cause notice, and simple show cause notice, which I'm defending in the High Court. I'll just say how I'm defending broadly, not detailedly, broadly. I hope that will be sufficient, and we'll see later. Defects raised in intimation notice under issued in form GSTR 01. Defect number 1, difference between input tax credit availed in GSTR 3B, auto-populated in GSTR 2A. Typical issue. How will you defend? I said it is submitted that in page number 40 of whatever the notice, show cause notice issued, a difference of 91,000 rupees was intimated as excess ITC claimed. It was intimated that it has to be reversed. It is submitted that the difference is due to non-compliance or delay in compliance on the part of the supplier, for which the petitioner can never be held liable. Due to this, penalty of 91,000 was proposed, which I am not ready to reverse. Further, it is paramount importance to note there is no element of criminality or fraud that can be associated with the petitioner. A show cause notice demand order in section 74 does not hold good in law and it is unconstitutional. This is my submission to the Madras High Court. Next, defect number 2 that they have notified. A reversal of ineligible ITC availed as required under section 17 subsection 5 of the CGST and TNGST, that is 2017. It is submitted that another defect in so-and-so page in the reference of the department blocked or ineligible to the extent of 21,000 rupees was availed. It was proposed to reserve the same. However, there was no ITC that were ineligible or blocked for the petitioner. For this tax demand of 5,000 along with a penalty was proposed. Further, no criminality or element of fraud. I'm saying I'm not blocked. That's all. Defect number 3. Turnover and tax difference due to GSTR 1 and 3B. GSTR 1 output tax, 3B will also have the summary of the output tax, right? You will not have the summary of the output tax in GSTR 3B. It is further submitted that another defect was raised stating the turnover of 990 rupees fraud. Turnover of 990. Can you attribute this to fraud? Okay. Between GSTR 1 and GSTR 3B, which is not at all material amount, this does not warrant a show cause notice and demand order, and it does not hold in good in law. It is further submitted that the defect is a tax demand of 990 along with the penalty of 990 proposed to be levied. So we have denied it on the ground of immateriality. Defect number 4, outward supply turnover difference. Outward supply turnover. So GSTR 1, 3B number vis-a-vis IT statement. Form 26 IT statement with the 3B compared. Okay, what difference you will draw? You tell me. Let's brainstorm. Now this is a show cause notice with you. They are comparing the turnover of your IT with the GSTR 1 output tax based on the income, based on which you would have paid the output tax, so that turnover they are taking, compared with GSTR 3B. They are saying all the three should be same. Will it be same in IT statement and in GST? Will it be same? Answer is no. You say categorically. Why? We have difference of accounting standard. With respect to accounting transaction, ICDS. All those important things, technical things you put. So, it is further submitted that the difference is purely due to applying the concept of accrual base of accounting in conjugation with the revenue recognition standard of the Institute of Chartered Accountants of India. And certain book entries are reason for the turnover book entry. Turnover difference. Let him examine what is a book entry. It is further submitted that the criminality or element of fraud cannot be attributed. See, it is further submitted that Customs, Excise and Gold Tribunal Delhi in had Hindalco Industry. This is Allahabad judgment. The demand raised merely on the basis of balance sheet cannot allege fraud or suppression, as much as the balance sheet is a public document. It is submitted that due to this tax demand of 51,000 was levied with the penalty. Further, it is a paramount importance. There is no suppression. Now coming back to the fifth defense. There is a difference between IT return vis-a-vis 26 AS. It is further submitted that another defect in so and so page of the was also raised stating that there was a short or non-reporting of a taxable turnover of 4 lakhs. So they say there's a short reporting of a taxable turnover of 4 lakhs. Then go and check whether your turnover is exceeding 4 lakh, 10 lakh, 15 lakh like that reported. Then you can take a difference. It is submitted that this amount is consumed or subsumed within the turnover. We say we have not missed, but it is within the turnover. Actually is missed. But we will take a defense. Disregarding my defense, let the department say what they have to say. They have to deal with all our submissions. You defend every number. So I say it is consumed or subsumed within the GSTR 3B, and due to which there is no wrong reporting of turnover in GSTR 3B. So it is further submitted. That's all is the submission. These are all basic defects, but there are many more defects of this kind. I just gave you a simple example. So whether you receive notice in 73 or 74 or section 129 issue, you are free to call me and we'll definitely discuss. I just try to make it very simple because you are in a residential seminar. You are not in a professional mode. So accordingly, I wanted to ensure that I don't tax you too much. But all that I want to tell you is you handle the GST notice very, very confidently. And believe we are there, I am there to support you. That is the question of law.
Okay.
Boldly you defend. You don't get into the don't get into agreeing on the coercive action. Don't fear. There's a case of a Swiggy, which is Karnataka State GST. What they did is they issued a notice to Swiggy. Sorry, they did an inspection, then subsequently they issued a summon. When they issued a summon, they agreed that they should pay tax when the summon is issued. The Constitution Court said that you should refund that amount because in the 74 route, you cannot coerce to pay. So there is Constitution of India. You saw many parliamentarians taking this book and showing in the parliament. You also, as a chartered accountant, carry this constitution and show that constitution, and beside constitution there is Ambedkar always there. It may be dramatic to close this session with this tone, but the fact of the matter, it is a reality. So this is a very, very powerful, I'm not promoting EBC publication. If you want to show, I'll show some other bar act, but it is handy. So when you go and deal with the officer, keep it on the table and say, you have constitution with you. And definitely that will protect all your assessing. Because for a single thing, because you are only looking at the legal right. Because you're always certain times guilty that you handle the compliance and now your client is in trouble. Don't get into the guilt trap. Neither you are right, neither the department is right. Even if both are right, it should be constitutional. Constitution has no right and wrong. Constitution is constitution. It is a separate way. So don't feel guilty because you are always like when the client comes and says, sir, notice vandirukuna udane neenga thappu panna mariye nenichikrom namba thappu இந்த தப்பே பண்ணல ஹேண்டில் பண்ணும் அவ்வளவுதான். We have to handle. But without chartered accountant, GST cannot sail. Without lawyer, it can sail. Without chartered accountant, it cannot sail. I know, because returns are not filed. You think what will happen? File பண்ணியே உங்களால டிஃபெக்ட் கரெக்டாக கண்டுபிடிக்க முடியல. நான் ஃபைல் பண்ணாமல் இருந்தால் என்ன இருக்கும்? அப்பா பொசிஷன் ஆஃப் லா கரெக்டாக இல்லை, நான் ஏன்ப்பா ஃபைல் பண்ணணும்னு நீங்கள் விட்டுட்டு இருந்தால் என்ன பண்ணியிருப்பாங்க டிபார்ட்மெண்ட்? டு தட் எக்ஸ்டென்ட் டிபார்ட்மெண்ட் ஷுட் ஷோ gratitude to the chartered accountants. Already course is tough and clients are tough. And business complexities have increased. Business models are evolving. Value chains are expanding. Value chains are just not local value chains. It has an international relevance nowadays. Logistics has become complex because of aggregation, Uberization. So the price rise, tax payment, fee reduction. So many factors are contributing to the role of the professional. And I think it is very important we all move the ship of controversy on GST very confidently. Always remember, I am there for you in times of your question of law to support my fraternity, that is Chartered Accountancy Fraternity. Thank you so much for this wonderful opportunity. It's been long time. That I came to Pondi, and I've come for different work, meeting governor and Aurobindo Ashram, Ramakrishna Mission work. But it's somehow CII, TAI, all those. Last week I was there. Some of my clients are also there in Pondi. So, but rarely I somehow missed the link of addressing. But I think it's the right time. I reconnected with all of you. I assure you that I'll visit the Pondi bench and help you all to sail this controversy of GST controversy ship that we are all facing. And we will transform this space of controversy into an opportunity to see to that we question the law in the right forum. Thank you so much to the chairman, to the members of the committee, to the organizers of the RRC. I think newly elected members have been announced.
Not yet, sir.
No, sir.
Not yet. Okay,
Not
it's
yet,
going on.
not yet.
I don't know when the election also happens. Just I participate. I don't know the dates.
It is approaching. It is approaching, sir.
Okay. All the best to all the people who contested the election. I just they come to my office for meeting me for the election purpose, but I just go and vote, but I don't know what is election dates, when is the results coming out. I know general election when it is coming out, MP election when it comes out, MLA election when it comes out. But I'm all the best to all the members who are participated, and I'm sure the institute will uphold, be a beacon of light for the new laws, that is especially with respect to revenue laws. And it's a joint effort that we all have to take up in transforming the space of litigation of the GST. Always I'm there to support all of you on technical matters. Any questions, I'm ready to take.
Many questions are there, sir. We will come through mail or also the WhatsApp. That is okay. If anything is any member want to raise any question, we can make use of this
Definitely,
opportunity.
Ranjit Kumar sir. Definitely. Thank you so much for inviting. And I can see you are in car and very happy. Happy to see you participating actively in spite of your driving experience. Thank you so much.
Any member want to raise question, they can raise their hand through that is in the option itself.
I think there is one question in the chat box which sir has already answered. Validity of SCN covering multiple years, maybe explain please. I think you have already covered, sir.
Okay. Validity of SCN multiple.
Okay, sir. Okay.
Harik Govind has asked me. I just covered. Yeah.
Okay, sir. Let's move on to the that is.
Thank you so much. There was big delay in starting the program. We wanted to bring the best of technology while we address. Hope the voice and the video was more accessible.
Okay, sir. Actually, we held up in the many hurdles. Sir, actually, in the RRC on the hurdle, it's a third invitation. First, we organized at Yerkad, but due to natural calamity, heavy rain prediction, it was postponed. Again, it was that is fixed at Coutrallam last 18, 19, 20 November. That time also we had a cyclone in Puducherry. So member they paid and then withdraw their participation. So we postponed. இப்போ போட்டுற பிறகு எல்லாமே ரெண்டு ஃபேக்கல்ட்டி வரல. ஸோ அவர் வி மேனேஜ் இட். இப்போ இந்த இது உங்களை பிசிக்கலா மீட் பண்ணணும் அப்படிங்கறத எங்களை எல்லாரும் எதிர்பார்த்துட்டு இருந்தோம். அவர் டிராவல் சில இதுல வி கேன் நாட் மீட். பட் ஆன்லைன்ல நேற்று எல்லாம் டிக்ளேர் பண்ணிட்டோம். ஆக்சுவலி இங்க ஒரு பக்கத்துல ஃபால்ஸ் மார்னிங்கே எல்லாம் கிளம்பியாச்சு. ஸோ அங்க என்ன ஆச்சுன்னா ஒரு அன்டியூ கன்ஜஸ்டட் ஆயிடுச்சு டிராபிக். 1.5 hour அங்க டிலே ஆயிடுச்சு. ஸோ அதே இடத்துல நெட்வொர்க்கும் இல்லை. ஸோ ஒன்லி லக்கிலி வி ஹேட் த டவர் இருந்தது, பேச முடிஞ்சது, நெட்வொர்க் இல்லை. ஸோ அந்த கேப்ல இந்த ஆப்பர்ச்சுனிட்டி வச்சு ஒரு மீனாட்சி சுந்தர் சாரை கான்டாக்ட் பண்ணி வி மேட் ஹிம் அஸ் த ஹோஸ்ட். So I think we honor our commitment, whatever we give to our member.
Sure, definitely, sir. Anytime, sir. We'll have multiple Zoom interactions. You let me know for CP seminars. So my support is always there for the brand, sir. And even when you want to have a Zoom, we have a best of technology.
That session a classical one.
Yes, sir. And anytime for the branch, we can have multiple interaction for the Zoom. And rest yourself and enjoy in the peace of your residential seminar. And thank you so much. And I look forward to meet you all. Thank you. I really enjoyed the conversation.
Yes. Right, sir. Thank you. Actually, the what of the presented by secretary, but he is also have the network problem buffering. So that I take care that what of things. I have to thank first our chief guest, past chairman of SIRC, Raja Rajeshwaran sir. Actually, he also gave the much important to this RRC. Whenever I postpone, but I had difficulty with resource person. They are already preoccupied. When we postpone the next date, they will not be available. So Raja Rajeshwaran sir, he gave full support, and also he fully accepted for the date whatever we fixed. And also I thank all the resource person, particularly Sathya Kumar sir. You also actually cooperated very well. We tried our best to bring you to the physically to the Coutrallam, but however we will meet you, sir. But we had the wonderful opportunity interacting with you, sir. So we will meet you again, sir. I thank
Thank you.
all the participants, all the committee members, those who helped directly or indirectly. I express my gratitude to all. So thank you very much, sir.
Thank you,
We'll
sir.
meet you,
Thank
sir.
you. Sure. Thank you, sir.
Thank you, sir.
Okay.
Thank you.
I have to. A special thanks to Meenakshi Sundar, sir. Without him, it's not possible to conduct it.
Welcome, Chairman. Okay, thank you all.
Yes, sir.
We'll end the session.
Thank you, sir. Yes, we can conclude.